A question that many young attorneys have as they approach trial is, how do I get my evidence in? What they're really asking is, what is the foundation that I have to lay? I have found in conducting almost 200 civil jury trials over 34 years that that question is one that is perplexing more in its asking than in its application. The most important thing that you need to consider when you're trying to get evidence in is, do I have the right witness? It can be someone who has written a document, someone who's received a document. It can be a custodian of records for a business. It's a matter of getting the right person there, not necessarily the niceties of authenticating a particular type of evidence. And I'll illustrate this. Say that you have an email that someone has written. It's very easy to lay the foundation for its admission, because you look at, what do I have to do to let the judge know that this is authentic? That's all the foundation you need to lay. So it would go something like this. Please look at exhibit number 6. Your Honor, for the record, exhibit number 6 is an email dated January 6, 2012, addressed to the President of the United States. It was purportedly written by Amy Brooks. Now, Miss Brooks, please look at exhibit number 6. Do you recognize what this is? That's a key question. Do you recognize what this is? Her answer lays the foundation and authenticates it. Yes. Now, a lot of people just say, what is it? Some judges may require a second question. How do you know what it is? And she then explains, I am the person who wrote this email. Third question, what is it? It is an email that I wrote to the President of the United States. Your Honor, I move exhibit number 6 into evidence. That's all the foundation that you have to lay for it. If you're looking at letters, it's the same way. You can do it someone who has received it. Joe Jones is on the stand. Mr. Jones, please look at exhibit number 8. Your Honor, for the record, exhibit number 8 is a letter dated February 9th, 2014. It is on the letterhead of the law firm of Dewey, Cheatham, and Howe, and it's written to Mr. Jones. Mr. Jones, do you recognize what exhibit number 8 is? What is it? Your Honor, and this is a letter, excuse me, you have one more question. And this is a letter that you received? Yes. Do you recall receiving it? Yes. What did you do with it? He then tells you, you say, Your Honor, I move exhibit number 8 in. You can do it with photographs. Have you seen the scene depicted in this photograph? Yes. What is it? And you have them explain the scene. Or you can ask them first, have you been to, describe the scene? They'd say yes. Do you remember what it looks like? Yes. Please look at exhibit number 12. Your Honor, this purports to be a photograph of the scene. Mr. Arnold, do you recognize what's depicted in this picture? Yes. What is it? And the key word for photographs. Does this photograph fairly and accurately depict the conditions at the scene? If he says yes, Your Honor, I move exhibit number 14 into evidence, or exhibit number 12. The point is, all that you have to do is, through the mouth of a witness, show familiarity with the document. That lays the foundation, that authenticates it, that gets it into evidence. If you think about it, it's not really that difficult. You shouldn't be afraid. I'm Steve Young. I'm masteringthecourtroom.com and youngontrials.com. We're going to continue to do these podcasts. Please check out my websites, masteringthecourtroom.com. Thank you.